Try to forward to them, but I will not wait for them. Maybe they can join while the proceeding was going on.
Yes, my lord.
This matter is for judgment. The judgment is ready. So it will be read shortly. This is the judgment of the court. The claimant instituted this action against the defendant via a general form of complaint dated 23rd day of September 2020 and filed at the registry of the court. The general form of complaint was accompanied by a statement of facts, list of witnesses, statement on oath of Mr. Godwin A. Idigbe, and photocopies of documents to be relied on by the claimant. And relied by the claimant. In the general form of complaint, the claimant claim against the defendant as follows. 1. An order directing the defendant to compute and pay claimant benefit forthwith with A, the sum of 550,000 naira being claimant's terminal benefit, B, the sum of 610,000 naira being fixed payment to drivers, C, the sum of 26,000 naira being annual leave benefit allowance for the period between September 2015 and November 2016. D, the sum of 10,000 naira together with certificate wristwatch being long service award. 2, an order for issuance of certificate of service to the claimant as contained in the conditions of service. 3, the sum of 400,000 naira being cost of this action. A reaction to the defendant's processes, in reaction to the claimant's processes, the defendant filed statement of defense on the 18th day of December 2020, accompanied by witness statement on oath of its sole witness, with leave of court granted on the 31st day of March 2020. The defendant filed list of additional witness with witness statement on oath accompanying it. On the 18th day of January 2021, the claimant filed a reply to the statement of defense. On the 31st day of March 2022, the claimant testified as CW1 in proof of his claim. Thereafter, he was cross-examined on the 28th day of June 2022. The defendant on his part called one Mr. Linus Tuku, who testified on the 10th day of November 2022 as DW1. In defense of the defendant DW1 at the conclusion of his evidence in chief was cross-examined, and in the absence of examination, DW1 was discharged and the defendant closed his case. At the close of testimony, parties were ordered to file their final written addresses. The case of the claimant. The claimant's case, as can be gathered from the originating processes commencing this suit and the reply to the statement of defense, is that by the letter of employment dated August 16, 2006, which was admitted in evidence as Exhibit C4, the claimant was employed by the defendant as a dumper operator, heavy-duty driver, by the defendant. The employment of the claimant was regularized by the Exhibit C3, while his employment was terminated on the 24th day of November 2016 by the Exhibit C2. The claimant averred in his statement of facts that he is entitled to payment of his terminal benefit in the sum of 550,000 naira, 610,000 naira being driver's fixed allowance, 26,000 naira being leave allowance, and 10,000 naira and wristwatch certificate and wristwatch being long service award. The claimant is also claiming issuance of certificate of service as contained in the conditions of service and the sum of 400,000 naira as cost of this action. The case for the defendant hinged its defense on reconciliation and also economic downturn as the reason why the claimant's terminal benefit were not paid. It also stated that it is an ongoing process which involves both parties. It was also stated that the claimant is not entitled to driver's allowance and the leave allowances claimed as a policy was inapplicable in its location of service and for not fulfilling the condition precedent thereto, respectively. On the long service award, it was stated that the claimant is not entitled to long service award, as same is not obligatory but discretionary. It was also stated that the claimant has not applied and demanded for the certificate of service. If he had applied and demanded, it would have been issued to him. On the cost of litigation, the defendant stated that it is against the public policy for claimant to pass the burdens of payment of professional fees of his solicitors single-handedly engaged by him to the defendant. The submissions of the defendant formulated twin issues for determination. They are: one, whether the claimant has successfully proved his case by preponderance of credible evidence as required by law as to entitle him to judgment. Two, whether the claimant is entitled to the claim for payment of his solicitor's fees by the defendant. Argument on the issues were canvassed. I have captured the argument on the two issues, so I will keep reading the argument of counsel. Counsel will have the benefit of reading it when they collect the hard copy of the judgment. The claimant on its part also formulated twin issues for determination. The argument of counsel have been captured in the body of the judgment, and a reply on point of law was filed by the defendant that has also been captured in the body of the judgment. I now go straight to the decision of the court. I have carefully and painstakingly examined the processes filed in this case, the evidence laid by the parties in proof of their respective position. I have equally considered the final written addresses of the parties and the listening attentively to adumberation by counsel for both parties. It is apt to state here that it is the relief sought by claimant that determines the nature of the case put forward before the court for adjudication. From the reliefs being sought before the court by the claimant is not contesting the termination of his employment. The relief being sought borders on unpaid entitlement and allowances of the claimant. In the case of Gabriel Atibi versus Kabel Metal Limited, it was held by the Supreme Court that a claim is circumscribed by the relief's claim, and the duty of a claimant, therefore, is to plead only such facts and materials as are necessary to sustain the reliefs and adduce evidence to prove same. In the case at hand, the duty of the court here is to see if by the evidence adduced before it, the claimant has been able to prove entitlement to any of the reliefs being sought. In the circumstances, I shall consider the reliefs being sought by the claimant before venturing However, before venturing into consideration of the reliefs, I shall give a brief summary of the parts of the case which are germane to the issues for resolution. It is in the evidence that the claimant was by the Exhibit C4 offered employment by the defendant on probation for 6 months. By the Exhibit C3, the claimant's employment with the defendant was regularized with effect from 1st day of November 2007. However, by the Exhibit C2, the claimant was disengaged from the employment of the defendant with effect from 20th day of December 2016. The reason given for the disengagement are reorganization and economic downturn. The defendant has failed and refused to pay the claimant his entitlement, his terminal benefit, leave allowances, fixed driver's allowance, and issuance of certificate of service. The defendant in his defense stated that the claimant claim could not be paid due to economic downturn, and there has to be reconciliation before such payment can be made, as the claimant has taken a lot of loans from the defendant. It was also the case of the defendant that the claim of the claimant is speculative, vexatious, and unmeritorious. First, it is to be noted that the claimant's claim can be categorized into twofold. Firstly, the relief in this category are monetary claims, which means they are claims for special damages that must be specifically claimed and proved strictly, as enjoined by the decision in the case of NNPC versus Kilifo Nigeria Limited. The second category is the relief seeking for issuance of certificate of service. What this court is saddled with the responsibility of determining is to see if the claimant has, by the evidence adduced before the court, is entitled to any of the reliefs being sought. However, before considering the viability of the claimant's claim, I shall at this juncture deal with Exhibit 8. The claimant has pleaded staff handbook as the instrument he is relying to make the claim before the court. The document tendered and admitted is in evidence as staff handbook is Exhibit C8. The counsel for both sides referred to this document as Exhibit 8 as staff handbook. However, in the final written address, the said Exhibit C8 was considered to be a collective agreement. This means that Exhibit C8 was taken by the plaintiff parties to be staff. There is a world of difference between staff handbook and collective agreement. Staff handbook, when it comes to issue of employment, is the document that the employer issues to his employee after an employee has accepted the offer of employment made to him. It is a document that regulates the conduct of employment in the course of his conduct of an employer, conduct of an employee in the course of his employment with the employer. See the case of Umera versus NRC, reported in 2002, 10 Nigerian Employee Report, Part 1838, page 349. While collective agreement is the negotiated formal rules and conditions regulating working conditions and terms of employment in collective labor relations. In other words, collective agreement is the negotiated terms and conditions of service between the union of employees or their representative and the employer or employers association. See section 91 of the Labor Act. I have Peru's Exhibit C8. It is clear to me that going by the exposition of the law, Exhibit C8 being product of negotiation between the National Union of Mine Workers and the defendant, is a collective agreement and not staff book, as both parties seems to have considered it to be in their respective pleading and evidence before the court. Having resolved that Exhibit C8 is not a staff handbook but collective agreement, it will be treated as such in this judgment. As pointed out earlier, in this judgment, the claims are subscribed by the relief sought, and a party is to adduce sufficient evidence in proof of the abandonment. On the claim of the claimant, the first set of reliefs, the claimant is seeking from the court borders on payment of the sum of 550,000 naira, being claimant's terminal benefit, the sum of 610,000 naira being fixed payment to drivers, and 226,000 naira being annual leave benefit allowance from the period of November 2015 to November 2016, and the 10,000 naira together with certificate, wristwatch, and long service award. In labor relations, the burden is on the claimant, who claims monetary sums to prove not only the entitlement to the sum, but how she came about the quantum of the sum. And proof of entitlement is obtained by reference to an instrument or document that grants it. See the case of Mohammed Dungus and others versus NENL Consortium Limited, reported in 2015, 60 NLLR, part 208, page 39. Note the claimant in this case ties his monetary claim to the provisions of Exhibit C8, collective agreement. Extensive arguments have been advanced by counsel for both parties in their final written addresses before the court on the impossibility of collective agreement. The counsel for the claimant insisted that Exhibit C8 is applicable to the case at hand and is enforceable by this court, while counsel for the defendant is of the view that Exhibit C8 is not applicable because the claimant is not a party to the agreement. As a general rule, collective agreement is not justiciable and devoid of legal sanction. See the case of Texaco versus Kende. See also Wajabu versus Baiko. The reason for this general position is that there is no intention to create legal relation by the parties to collective agreement. That's why in Nigerian Arab Bank Limited versus Shuaibu, it was observed that the collective agreement is at best a gentleman agreement and extra legal document devoid of sanction, as it is a product of unionist pressure. However, development in contemporary labor jurisprudence, especially in Nigeria, where the National Industrial Court assumed a strong radical position on enforceability of collective agreement, the old position is fast changing and has indeed been held to be no longer tenable under the Nigerian labor law. See the case of Pegasus versus Schumer, reported in 2008, 11 NLLR part 29, page 164. See also the case of Senior Staff Association of Nigerian Universities versus Federal Ministry of Education. A reported judgment of this court delivered on the 5th day of December 2016. Even in England, where we borrowed the common law position, the position has changed. The law has recognized two functions of a collective agreement. Firstly, contractual function between the parties who make the contract, that is the unions or union and an employer. Secondly, the normative function, which ensures that the rules made by the agreement are applied to the individual contracts of employment. This means that the issue of whether the agreement is a contract enforceable between the parties to it is a different consideration from the question of whether the agreed terms have been incorporated into the contract of employment so as to give legal teeth to the said agreement. Under the extant common law, only parties to a contract can sue and be sued. Other parties are regarded as strangers to the contract and cannot sue or be sued, nor can they be sued to enforce it. Such a stranger is also precluded at law and equity from enforcing a right or benefit conferred or accruing to him under the contract. He is not a party. Such is the circumstances of collective agreement. The workers who are members of trade union are strangers and not parties to collective agreement. See the case of ACB versus Idigbe. See also Union Bank of Nigeria Limited. The agreement are seen as themselves not of any legal significance unless and until the terms are translated into contractual relationship between the employer and employee. This is done by incorporation of the terms of the collective agreement into the personal or individual contract of employment. It is only such incorporation that the agreement becomes relevant. See the case of Union Bank of Nigeria versus Emmanuel Aderewaju Suarez, reported in 2012, 11 Nigerian Equivalent Report, part 1312, page 500. The incorporation may be expressed or implied. The Court of Appeal in ACB versus Idigbe held that as regards collective agreement, whether they are binding on the individual employer depend on a number of factors, such as their incorporation into the contract of employment, if one exists, the state of pleadings, the evidence before the court, and perhaps the conduct of the parties. In any event, the agreement would have been incorporated or adopted expressly or impliedly as part of the contract of employment between the parties. The institutions in any event, the agreement would have been incorporated or adopted expressly or impliedly as part of the contract of employment between the parties. The instances remain exceptions to the general rule as the employer and employee become privy and parties to the contract as against the rule of privity of contract, and they all suggest expression of intention to be legally bound, and the court will enforce the agreement unless there is an independent extraneous bar. For instance, perhaps the employees' proof of membership of the union, like which is the party to the collective agreement, is critical, just like other relevant factors. In Mrs. Risi Shuaibu versus Union Bank PLC, the court accepted that a collective agreement which was pleaded by the plaintiff and admitted by the defendant were binding on the parties. See also Aberagu versus SPDC and Nwobosi versus ABC. The defendant bank had pleaded a document the employer was held in the case of Cooperative and Commerce Bank Limited versus Okonko. The employer was held It is pertinent to point out here that the Said Alteration Act has modified the law relating to applicability of collective agreement to an employee and the extent or degree to which the employee can rely on such agreement. See the case of Agatha versus Onwara versus Access Bank. See Samson Kende versus Kendoy Union Bank. By Section 254C of the Constitution, as amended, which confers on this court jurisdiction, from the evidence before the court, there is no doubt that the parties, by their pleadings and evidence which establish reliance on Exhibit C8 by them in this case, is a proof that they have adopted Exhibit C8 as forming part and parcel of the terms and conditions of service governing the employment of the claimant. In this wise, Exhibit C8 is applicable to the contract of service between the claimant and the dependent, and they are bound by its terms. In a recent decision of this court, in the case of Asia Apium versus BSA Plantation Limited, suit number NICS/CS/21/2022, are reported delivered having found Exhibit 8, C8, to be applicable to the instant case, I shall proceed to determine the claim, whether the claimant has proved any of the reliefs being sought before the court. Relief 1A, which is for the sum of 550,000 naira, is for terminal benefit. The claimant, in proof of this head of claim, relies on the provisions of Article 5, Section 4 of Exhibit C7 of Exhibit C8. From the content of Exhibit C4 and C2, the claimant served the defendant from 1st of September 2006 to 20th December 2016. This means that the claimant served the defendant for a period of 10 years, 3 more. From From the content of Exhibit C4 and C2, the claimant served the defendant from 1st of September 2006 to 20th December 2016. This means the claimant served the defendant for a period of 10 years, 3 months. This has qualified the claimant to benefit from provisions of Article 4, Section 4B of Exhibit C8. The defendant had in its defense admitted not paying the claimant his terminal benefit for the simple reason that there has to be reconciliation, and also economic downturn has affected the business of the claimant. It was further stated that the exercise is an ongoing process. The defendant has not been able to prove the assertion on the reasons for non-payment of claimant's entitlement. It has also not supported the assertion with any provisions of the contract of service showing that the process is ongoing. It is clear to me the defense of the defendant on why the terminal benefit of the claimant was not paid is a sham and unacceptable. An employer who decided to do away with the service of his employee should not interrupt the proceedings. The failure of the defendant to pay the terminal benefit of the claimant is sheer wickedness. The claim that there is need for reconciliation is untenable, as there is no iota of evidence adduced before the court to support such a claim. There is equally no any evidence to establish that there is reconciliation or a reconciliation is ongoing. Therefore, the defendant has no basis whatsoever to deny the claimant his terminal benefit. I so find and hold. The next relief is relief 1B, which is for the sum of 610,000 naira as fixed payment to drivers. As pointed out earlier in this judgment, this monetary claim need to be specifically pleaded and strictly proved by the claimant. The claimant in proof is relying on Article 7, Section 2A of Exhibit C8, which provides that drivers shall be entitled to a fixed overtime of 5,000 naira per month. The claimant stated he served the claimant as a cat dumper from 1st day of September 2006 to 20th day of December 2020. The claimant stated that the defendant has refused to pay the fixed driver's allowance despite several demands. The fixed driver's allowance is for a claim over an overtime performed by drivers. The claimant has not adduced any evidence that he had performed the overtime to be entitled to fixed driver's allowance. In the absence of evidence that the claimant has actually performed or has done overtime over the period of his claim, the claimant has not proved entitlement to this relief. Same is hereby refused. On relief 1C, for the sum of 26,000 naira as being annual leave benefit allowance, it is provided in Article 9, Section 1 of Exhibit C8. In proof of this head of claim, the claimant stated that his last annual leave was in September 2015 and he worked subsequently till November 16, 2016, before his employment was terminated. The claimant tendered Exhibit C8 for the claimant to be entitled to payment of annual leave. He needs to show to the I quite agree with the defendant looking at the clear and unambiguous provisions of Article 19, Section 2 of Exhibit C8 there that the long service award is not automatic. It is at the discretion of the defendant. Therefore, this court cannot compel the defendant to make such an award. Relief 1D fails, same is hereby dismissed. Relief the claimant relied on Article 21, Section 2B to prove that he is entitled to this relief. There is no much dispute about this entitlement. The only answer given by the defendant is that the claimant has not applied for such certificate since the claimant was not summarily dismissed by the defendant. He is entitled to be issued with certificate of service on relief 2, which is for issuance of certificate of service. There is no much dispute about this entitlement. The only reply by the defendant is that the claimant has not applied for such certificate. Since the claimant was not summarily dismissed by the defendant, he is entitled to be issued with certificate of service in accordance with the extant rule. The claimant having served for 10 years, 3 months, he is entitled to be issued with certificate of service. The defendant is hereby ordered to align with Article 21 on the whole, the claimant has succeeded in proving some of his reliefs and failed in some. In view of the foregoing, the order of the court is as follows. The claimant is entitled to payment of the sum of 550,000 as his terminal benefit. The defendant is hereby ordered to pay the claimant the said sum of 550,000 as terminal benefit. The claimant having served the defendant for 10 years, 3 years, his employment having not been summarily dismissed, is entitled to be issued with certificate of service. The defendant is hereby ordered to, with immediate effect, issue the claimant with certificate of service in line with the provisions of the collective agreement. The claimant is entitled to cost. Cost is assessed in the sum of 300,000 naira. The defendant is hereby ordered to pay 300,000 naira cost to the defendant. All monetary sums in this judgment shall be paid within 21 days. The claimant is entitled to cost in the sum of 300,000 naira. Defendant is hereby ordered to pay the said sum to the claimant. All monetary sums in this judgment shall be paid within 30 days from the date of this judgment, failing which interest in the sum of 10% shall apply. Judgment is entered accordingly.
As the court pleases.
Call the next case.
Yes, my lord. Suit number NICN CA 30/2020 between Mr. Godwin A. Idigbe and Crushed Rock Industries Nigeria Limited. My lord, the parties are absent.
Any appearance?
Yes,
Any
my lord.
appearance?
May
Yes.
please the honorable court. May
Yes.
please the honorable court. I am
Yes.
Nnachi Egwu. Nnachi
Yes.
Egwu humbly appears for the defendant.
Any other appearance? Any other appearance? This matter is for judgment. The judgment is ready. This is the judgment. The claimant's general form of complaint dated 23rd day of September 2020 was received at the registry of the court on the same date, but payment of filing fees, which signifies the commencement of the action, was effected on 29th day of September 2020 by the general form of complaint and its accompanying processes. The claimant prays for the following reliefs. They are: one, an order directing defendant to compute and pay claimant his terminal benefit forthwith. A, the sum of 750,000 naira being terminal benefit. B, the sum of 1,020,000 being fixed payment to drivers. C, the sum of 32,000 naira to order for issuance of certificate of service to the claimant as contained in the conditions of service. 3, the sum of 400,000 naira being cost. Upon being served with the originating process, commencing this suit, the defendant filed with the leave of court granted on 31st day of March 2020, enter appearance and file statement of defense on the 18th day of December 2020, out of time, and the said statement of defense was deemed properly filed and served by the court. The defendant also, with the leave of court, filed additional witnesses and the witness statement on oath in respect of the witnesses. On the 18th day of January 2021, the claimants claim the case of the claimant. The facts that led to the filing of this suit are that the claimant was offered employment on the 16th day of October 1999 by the defendant. The appointment was confirmed 1 year and 2 months thereafter. The letter of employment and confirmation were lost. The conditions of service governing claimants' employment are as embodied in the staff handbook issued by the defendant. According to the claimant, by the Article 5, Section 4 of the conditions of service, provisions were made for payment of terminal benefits. The employment of the chairman was terminated since 20th. According to the claimant, by the Article 4, Section 4 of the conditions of service, provisions were made for payment of terminal benefit. The employment of the claimant was terminated since 20th day of December 2016, but his terminal benefit have not been paid, despite several demands. According to the claimant, he was offered employment by the defendant in 1999 and served for 17 years. He is therefore entitled to 750,000 as his terminal benefit. By Article 7, Rule Section 2A of the conditions of service, provisions were made entitling all drivers to fixed overtime. The claimant had his last annual leave in November 2015, subsequently worked till November before his employment was terminated. The claimant therefore is entitled to 32,000 being allowance for annual leave from the dependent. The claimant is entitled to long service award and certificate and
Good morning. How are you? Good morning.
it has been 4 years since termination of claimant's employment, and the dependent, despite several demands, has refused to pay the claimant his entitlement. Under cross-examination, CW1 testified that he started work with the defendant in 1999. He also stated that in paragraph 1 of his statement of facts, he never stated that he never stated that he was employed in 2020. The said statement in the statement of claim was wrong, that he lost his letter of employment. He stated that he is entitled to leave allowance for working for 12 calendar months, that he was being paid 1 month salary for leave allowance. His salary is 32,000 naira. There is provision in the handbook for long service award and long service certificate, and is not by application. He is a driver in Calabar, and that he has not been paid driver's allowance for 17 years. He worked with the defendant. The driver's allowance is in the handbook and is not only for Abuja, but for all branches. The case of the defendant denied ever employing claimant on the 16th day of October 2020. The defendant does not current the employment of the claimant being contractual is governed by the express term agreed upon and enshrined in the claimant's letter of employment and staff handbook. The payment of terminal benefit is an ongoing process involving both parties. The payment of terminal benefit is hampered by the current economic difficulties in the industry, but efforts are in top gear to actualize them. The policy on payment of driver's allowances does not apply to Akamfa, where the claimant served. It only applies to Abuja and Ishiagu queries. In view of the volume of demand from customers, In the written submissions of the defendant, twin issues were formulated. They are whether the claimant has successfully proved his case by preponderance of evidence as required by law. 2, whether the claimant is entitled to claim for payment of solicitor's fees. In answer to issue 1, counsel answered it in the negative, in that the claimant has failed woefully to discharge the evidential burden of proof placed on his shoulders by the law. Counsel submitted that the burden of proof lies on the claimant, who asserts to prove by preponderance of evidence that the set of facts alleged to be in existence actually exists. On this submission, reliance was placed on the section 133 of 131, 132, and 133 of the Evidence Act. Therefore, the burden of proving entitlement to terminal benefit, fixed payment, leave allowance, labors, on terminal benefit, it is submitted in proof of the claim. Before the court, the claimant tendered various documents which were admitted as exhibit. The claimant contended that by the conditions of service as enshrined in the workers' handbook, he is entitled to payment of terminal benefit, having successfully served the defendant. For the fixed payment on drivers, it is submitted under cross-examination on 20th day of June. CWO confirmed the position that the defendant when he answered that I did not receive driver's allowance, they don't pay it in Akampa. The above answer by the claimant as CW1 is a confirmation of the abandonment in paragraph 4 of the statement of defense and paragraph 7 of the statement on oath of DW1 respectively. Moreover, staff in the category of claimant do not qualify as drivers for purposes of entitlement. Entitlement to the allowance. The claimant was employed as a car dumper operator as shown in exhibit. On leave allowance, it is submission of counsel for the defendant that the condition for payment has not been fulfilled, and the claimant has not served for 12 calendar months to be entitled to payment of leave grant. On long service award, it is the submission of counsel that contrary to paragraph 7, the statement of our claimant is not entitled to any long service award of 10 years, as same is not obligatory, but purely at a discretionary level. Counsel insisted that by the unambiguous provisions of Article 19, Section 2, and proviso thereto, the claimant is not entitled to be granted this relief as it is discretionary upon the management of the defendant. Counsel argued that when a duty is discretionary, it is entirely the prerogative of the authority and it cannot be compelled to do so see the case of UBA versus Astra Builders Limited. Council submitted in view of unambiguous provisions of articles in the Exhibit C8, the claimant is not entitled to any of the reliefs being sought. On solicitor's piece, it was submitted that it is wrong for the claimant to pass over to the defendant his solicitor's fees, which he agreed with his counsel and to which the defendant is not a privy to. Counsel refers to several cases to back his submissions. Counsel submitted that there is no justification whatsoever, both in law and equity, for the defendant to shoulder the responsibility the defendant was not privy to the contract, and he cannot be compelled to pay for the services rendered to the claimant. Counsel urged the court to refuse the said reliefs. The submission of the claimant submitted two issues where claimant has successfully proved his case by credible evidence. Two, whether the claimant is entitled to claim for payment of cost. In arguing issue one, counsel submitted that it is not a principle of law that you who assert shall have the burden of proof of his assertion. He relied on section 131 to 134 of the Evidence Act. Counsel continued his submission that where a claimant has satisfactorily proved the facts asserted, the burden then shifts to the defendant to rebut such assertion. The evidential burden is not static, as it may shift. According to counsel, the claimant has pleaded and gave evidence and also relied on instrument, that is conditions of service, to prove his case before the court. Counsel urged the court to grant the reliefs of the claimant. On the argument on solicitor's fees, counsel submitted that this court has the power to grant cost to a party. Several cases were decided and relied on this. Counsel submitted that the claimant has proved all the reliefs being sought and urged the court to grant same. Council submitted that the words used speaks for themselves, and they should be interpreted literally. Several cases were cited in support of this. Leave allowance, Council submitted that the claimant is entitled to be granted leave allowance having served the dependents from September 2015 to November 2016. In response, the council to the defendant filed a reply on point of law and on award of cost. Council refers to the holding of HMB Echo JSC as season was in Mekwe versus Emirates Airline, where he said, I agree with the appellant that the deducing from the foreign garage Council submitted that the Supreme Court has in many cases exercised discretion and granted cost. According to Council, the claimant has been stressing from the inception of this matter that he is entitled to cost. The claimant has testified in this matter before the court. Council continued his submissions that the defendant has made heavy weather on the claimant's claim for cost of this action. However, the defendant has not denied the fact that the claimant inquired express inhumanity if he is to meet up. Council asked the court to resolve the second issue in favor of the claimant and including the concluding his submission. Council submitted that in view of the admitted facts and unchallenged evidence of the claimant, Council asked the court to resolve the two issues in favor of the claimant. Court decision: I have considered the processes filed in this case, the evidence laid by the parties in proof of their respective stance. I have equally perused the final written addresses of the parties. I listened attentively to oral submissions by counsel in adumbration. From the pleadings and evidence before the court, the facts of this case are straightforward and not much in dispute. The crux of the claimant's claim is that for over 4 years after the defendant has terminated his appointment, the defendant has failed and refused to pay the claimant his terminal benefit, leave allowances, fixed driver's allowances, and issuance of certificate of service. The defendant on his part stated that the payment of terminal benefit is an ongoing process and that there is need for reconciliation before it can be paid. It is to be noted that the claimant's claim was categorized into two. The first set of reliefs are monetary in nature, while the second, the relation to issuance of certificate. What this court is saddled with the responsibility of determining is if the claimant has, by the evidence adduced before the court, entitled to any reliefs. However, before considering the viability of the claimants, the address counsel of the parties, the claimant has pleaded staff handbook as the instrument he is relying on to make the claim before the court. The document tender admitted its evidence as staff handbook is Exhibit C7. The counsel for both sides referred to it in their pleadings and the evidence as Exhibit C7 as handbook. However, in the final written address, the said Exhibit C7 was considered and referred to as collective agreement. This means Exhibit C7 was considered by the parties to be staff handbook as well as collective agreement. However, there is a world of difference between the staff handbook and the collective agreement. Staff handbook, when it comes to issue of employment, is the document that the employer issue to his employee after the employee has accepted to offer employment, to be offered employment. And I have perused the exhibit C7. It is clear to me, going by the exposition of the law, exhibit C7 being product of a negotiation between National Union of Mine Workers and the defendant is a collective agreement, not a staff handbook, as both counsel seems to have agreed on that in their pleading and evidence before the court. Having resolved that exhibit C7 is not staff handbook but collective agreement, it will be treated as such in this judgment. The first set of reliefs being claimed by the claimant borders on payment of 750,000 being terminal benefit, 1,020,000 as fixed driver's allowance, and 32,000 leave grant, and 500,000 cost. In labor relations, the burden is on the claimant who claims monetary sums to prove that not only entitled to the sum, but how she came about the quantums of the sum. And proof entitlement is obtained by reference to the instrument which granted such an entitlement. The claimant in this case ties his monetary claim to the provisions of Exhibit C7 as collective agreement. Extensive argument have been advanced by counsel for both parties in the final written address. The counsel for the claimant insisted that Exhibit C7 is applicable to the case before the court, while the counsel for the defendant is of the view that it is not. As a general rule, collective agreement is not justiciable and devoid of legal sanction. See Texaco versus Kende and Uwajabu versus Baiko. The reason for this general position is not far-fetched, as it is, there is no intention to create legal relation by parties to collective agreement, because such an agreement is being made under the union pressure. However, development in contemporary labor jurisprudence, especially in Nigeria, there have been exceptions to the general rule or deviation from it, and the old position is no longer tenable under Nigerian law. See the case of Pengasan versus Shuma. See also Senior Staff Association of Nigeria versus Federal University of Education. Even in England, where we borrowed the common law system, they have shifted away from the old position of the law. The law has recognized two functions of collective agreement. The first is contractual function, and the second, the normative function. As a contract, a collective agreement is considered to be not to be applicable to workers because they are strangers to it. They are not party. See the case of ACB versus Nwadike. Union Bank of Nigeria versus EDET, NNB PLC versus Egun, AfriBank versus OC The Court of Appeal in the case of ACB versus Idigbe has formulated a guide to whether a collective agreement can be applicable to a case or not. The court is of the view that it depends on a number of factors, such as the incorporation into the contract of service, if one exists, the state of pleading and evidence before the court, and perhaps the conduct of the parties. This means that the parties may, when conducting, if they conducted themselves in such a way that it will be in fact that they have adopted a particular collective agreement, then they will be bound by it. In any event, the agreement would have been incorporated or adopted expressly or impliedly as part of the contract of employment between the parties. The instances remain exception to the general rule as the employer and employee becomes privy and parties to the contract as against the rule of privity of contract, and they also suggest express intention to be legally bound, and the court will impose the employee in several cases. The courts have held that collective agreement is applicable because it was incorporated either expressly or impliedly into the conditions of service. See the cases of Risi versus Shaibu, Uwobosi versus ABC, and Abalogum versus SPDC. See also Cooperative and Commerce Bank Nigeria Limited versus Okonko, where such there is express or implied adoption, a party will be stopped from denying or refusing the applicability of collective agreement to the contract of service. It is pertinent to point out here that the third administration has modified the law relating to applicability of collective agreement to an employee and the extent or degree to which an employer can From the evidence before the court, there is no doubt that the parties, by their pleading and evidence, it is clearly shown that they have adopted Exhibit C7 as their conditions of service, as it forms part and parcel of the terms and conditions of service governing the employment of the claimant. In this wise, Exhibit C7 applies to the contract of service between the claimant and the dependent, and they are bound by its terms. A recent decision of this court in the case of Asia Epium versus BRC Plantation, suit number NICL/CS/21/2020, a reported the judgment of which was delivered on 9th March 2023. This court considered applicability of a collective agreement to the employment of the claimant, but it was found that the collective agreement, unlike in the case at hand, was not adopted expressly or impliedly by the parties. Having found that Exhibit C7 is applicable to the instant case, I shall proceed to determine the reliefs being sought by the claimant. Relief 1A is for payment of 750,000 as terminal benefit. The reason for non-payment given by the claimant, by the dependent, was economic downturn, and also that there is need for reconciliation. The claimant in proof of this said relies on Article 5, Section 7, subsection C7. From the statement of facts witness, statement of oath, as well as the statement of defense, the further witness statement of oath are replied. There is consensus between the parties that claimant served the defendant from 16th day of October 1999 to 20th day of December 2020. This means that the claimant served the defendant for a period of over 17 years. This has qualified the claimant to benefit from the provisions of Article 4, Rule Section 4C of Exhibit C7. I so find and hold. The defendant and his defense admitted not paying claimant his standard benefit on the ground of exercise is ongoing. This assertion has not been backed by any provisions of the contract of service, showing that the process is ongoing. It is also clear to me that the defense of the defendant on why the terminal benefit of the claimant was not paid is a sham defense and unacceptable. An employer who decides to do away with the services of his employee must be ready to, with immediate effect, be ready to comply with extant provisions regulating the relationships of payment of terminal benefit. The failure of the defendant to pay the terminal benefit of the claimant is sheer wickedness. The claim that there is need for reconciliation is also untenable, as there is no iota of evidence adduced before the court to show that there is any genuine effort to reconcile, to do any reconciliation between the claimant and the defendant, or need for such reconciliation. The allegation that the claimant took loans during his service has no basis, as there is no evidence adduced by the defendant to establish that the claimant indeed took loan from it and has refused to pay. The next relief is relief 1B, which is for the sum of 1,020,000 naira, which is for fixed driver allowance. This allowance is for overtime. It is paid to officers who have done overtime. There is no evidence before me to establish that the claimant has done overtime for the periods he served the defendant. If he had ever done any overtime, he would have stated it even in his pleading, but nothing of such was stated, and there was no any evidence documentary that was adduced before the court to show that the claimant has actually done overtime to warrant payment of this allowance. In the circumstances, the claimant has willfully failed to prove that he is entitled to overtime in the sum of 1,020,000 naira. The claim, having not been proved due to lack of evidence, is refused and same is dismissed. For relief 1D, for the sum of 32,000 naira as leave allowance, the claimant relied on Article 9, Section 1 and of Exhibit 2 or Exhibit C7 in proof of this head of claim. However, there is nothing before the court to show that the claimant has actually gone on annual leave. For an employee to be entitled to annual leave allowance, he must have shown or proved that yes, he has gone on the annual leave. Having not proved that he has gone on annual leave, this claim cannot be granted. Therefore, he failed woefully to prove due to lack of evidence. Same is hereby refused. Or relief 2 is for issuance of certificate of service. This is provided in Article 19, Section 2 of Exhibit C2. There is not much dispute about this entitlement. The only complaint of the defendant is that the claimant has not applied for such certificate. Since the claimant was not dismissed, summarily he is entitled to be issued with certificate of service in accordance with the extant rule. The claimant, having served for over 17 years, is entitled to be issued with certificate of service. The defendant is hereby ordered to issue certificate of service to the claimant in line with the collective agreement. On the whole, the claimant has succeeded in proving some of his reliefs and failed to prove some. In view of the foregoing, the order of the court is as follows. The claimant is entitled to payment of the sum of 750,000 as terminal benefit. The defendant is hereby ordered to pay the claimant the sum of 750,000 as terminal benefit. The claimant, having served for over 17 years, is also entitled to issuance of certificate of service. The defendant is hereby ordered to issue to the claimant certificate of service in accordance with the terms, in accordance with the collective agreement. The cost of this action is assessed to be the sum of 300,000 naira. The defendant is hereby ordered to pay the claimant the said sum of 300,000 naira as cost. All monetary sums in this judgment shall be paid within 30 days, failing which 10% is in interest per annum shall apply. Judgment is entered accordingly.
As the court pleases.
Yes, the registrar called the next case.
My lord, we are sorry.
Yes. Yes, I'm with you, counsel. You have muted, unmute yourself. You have muted your microphone. Unmute yourself. You should
Hello,
unmute
sir.
yourself. Yes.
Yes, sir. Can you hear?
You have muted yourself. Okay. Yes.
Yes, my lord.
Can I be heard now?
Yes, my lord.
Yes.
My lord, my lord, may we announce our belated appearance, sir. My lord, we are sorry for coming in late. My name is Linus Mbe.
You say?
My lord, we are sorry for coming late. My name is Linus Mbe.
I can't record you, and unless I see your face is not shown. You have to on your camera if you want to be recorded.
Yes, my lord, my camera is on now.
Okay.
Yes, my lord. My lord,
Yes.
I am Linus Mbe. My lord, I am humbly appearing with my learned friend. UC Echo.
UC Echo.
Yes, my lord, UC Echo.
Okay.
My lord, for the claimant.
Echo, EKWO.
My lord, EKOP.
Okay, EKOP.
Yes, my lord, for the claimant.
Yes,
My lord, we thank you for the judgment.
you are welcome.
We are grateful. Thank you.
You are welcome. Registrar, call the next case.
Yes, my lord. Suit number NICN CA 162023 between Dr. John Abasi of 4 and 1, Government of Cross River State of Nigeria. 2, Attorney General and Commissioner for Justice, Cross River State. 3, the Commissioner for Land and Urban Development, Cross River State. My lord, the parties are absent.
Yes, appearance. 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 Counsel, sit down and announce your appearance while sitting so that I can hear you. Don't be too far from the camera, from the microphone. Unmute yourself, counsel. You have muted yourself. Unmute yourself. Yes, appearance.
Yes. My lord, I'm Elder Ofem O Mba.
Elder Open.
O Mba. OFEM for Ofem. OFEM. FEM.
Yes.
M. O Mba. My lord. Ofem O Mba. Yes.
Okay,
Mba.
okay.
MV. My lord, my humble appearance
Appearance
is for the
who?
claimant. My humble appearance for the claimant.
Yes.
My lord, before you, we have a motion on motion ex parte.
Motion ex parte for what?
For an order of interim injunction restraining defendant respondent by themselves or through their agent, servant, privy, workmen, or other howsoever call from evicting, selling, dealing, or interfering with operation of a house allocated to the claimant, official quarter allocated to the claimant. Who is a civil servant, the Director of Public Health in the Ministry of Health and Disease Control.
Yes, counsel. What is the urgency of this application? What is the urgency in it?
Yes, my lord. My lord, we have filed a complaint before the court. We
are not
also
saying you have not filed. I'm asking what is the urgency in this matter that will require giving an interim injunction?
Restraining. Yes.
What is the urgency?
Require the interim injunction because, yes, my lord, my lord, the claimant, while is still in public service, and was allocated these quarters some times ago. And then while still in service, a quick notice was served on him to vacate, telling him that the property has been sold. With that first give him an first offer to accept or reject as provided under Monetization Act. And he had been given 21 days notice within which to pack, otherwise he will be ejected. And this notice is due to expire on the 24th of April, as contained 24th of April 2023. And that if this restraining order is not given, the claimant, the defendant may go ahead to eject him and will suffer untold hardship. And what he will suffer cannot be incurred even at the end of this suit. And so we wish that he be protected from further action, especially as the defendant has in several occasions.
Counsel, what I want to know is what is the urgency? You know, it's not whether he can be compensated. That one is not at this stage. It's when we are hearing the motion for interlocutory injunction. That is when that issue of whether he can be compensated or not will come up. As at this stage, since it's an ex parte, what is important is the urgency of the matter. That what prevents you from serving them with the motion on notice that will warrant the court to grant an interim injunction. That's what I want to know.
Yes, my lord, there have been served motion on notice.
So if you have served them, what is the problem then?
Then the defendant are still going ahead to disturb the occupation of the claimant in the property.
If they are aware, you should know what to do. We
serious threat of ejecting him out.
What I'm saying is, insofar as you have served him with your application for interlocutory injunction, the law requires them to stop doing whatever they are doing concerning that until after the court has heard and disposed of the matter. So if they now goes and tamper with the subject matter, you can come for an order to reverse whatever they have done.
My lord, we wish the rest
interim injunction. Wait, let me explain things. Interim injunction can only be granted if you cannot serve the motion for interlocutory injunction. Insofar as you can serve, there is no urgency in it. Once the date will be given for the hearing of the application.
My lord, we wish the court do us a favor to protect the rest, to avoid intimidation and harassment that is going on in the property.
Counsel, the court can only act in accordance with the law. The law on interim injunction is that there must be serious urgency for the court to grant it. And that urgency is if you cannot serve the party with the processes, that is when you can ask the court to issue an interim order of injunction. But insofar as you can serve the party, you can serve the other party, then you have no business asking for ex parte.
My lord,
you move the court to hear the interlocutory injunction as quickly as possible.
My lord.
Yes.
My lord, we have moved the court believed to serve the motion on notice, but they have not yet been served.
Yeah, Mr. Umba. Mr. Umba.
The registry can confirm that, the clerk of the court can confirm that they have not yet been served. I wish, especially as even not yet the medical doctor.
Wait, it's not they have
my
not
lord,
yet been served.
I'm on.
It's not whether they have been served or not now. Since you told me they have been served, and now you are saying they have not been served. The issue is, what is the urgent? Why can't you serve them? What stops you from serving them? Why have they not been served? It is only if you cannot serve the processes, that is when you come for interlocutory injunction. Maybe if the act they want to do is tomorrow, and you cannot serve them today, that is when you come before me and ask for interim injunction. When did you file this application? You file it on 18th.
Yes, my lord.
So if you can file it on the 18th, what stops you from serving them? What stops you from serving them on that 18th or yesterday?
My lord, is the officials of the court act to serve, and they have been moved to do the service. But
They have moved to where?
the threat the claimant is going through at this moment, I mean, the threat the claimant is going through from the officials of Ministry of Land is what have made us to come before this court for this restraining order pending.
Sir, you have made the director lands as one of the parties. Is it commissioner or director land? Go and serve him.
The commissioner for land has been made a party, and the attorney general has made.
Go and serve the commissioner for land with the process. Go and serve them. Go and serve them with the process. Interim injunction is only in cases of extreme urgencies that the court can intervene and grant it. And one of the instances of extreme urgency is if you cannot serve the party with the originating process and the application for interlocutory injunction. And it was not here, it was not the case here. It was not the case here. Which exhibit the notice they serve, which exhibit is it?
My lord, the reason why we are approaching this court for this restraining order is because what the claimant and his family is passing through on daily threats because of the short period of handing over. They want to do everything possible to dislodge the claimant from the official quarters, which due process have not been followed. And if that is done, the claimant will be put in a very serious, tight situation. As regards to this, the 7 days. Yes, my lord.
I will grant you accelerated hearing. I will grant you accelerated hearing. I will grant you, but this is a case in which you're supposed to put them on notice. I will grant you accelerated hearing.
Yes,
let me write. I have listened to you. Let me write what I want to write. Then I will read it out to you. Registrar.
Yes, my lord.
Registrar, not you.
Yes, my lord.
Check your diary.
Yes, my
Let
lord.
me see. Next week will be, let's see, Monday, Tuesday, Friday. Next week, Friday. What is next week, Friday?
And on next week, Friday is 28th.
Okay. Yes, counsel, listen to what I have. My ruling.
Yes, my
After
lord.
listening to counsel for the claimant, for an order of interim injunction, it is my view that this is a case in which the defendant should be put on notice. In the circumstances, I hereby order the originating processes together with the motion on notice for interlocutory injunction to be served on all the defendants in this case. The parties, all the parties in this suit are hereby ordered to maintain status quo and not to do anything that will in one way or the other jeopardize the hearing and determination of the motion on notice for interlocutory injunction, which is to be heard on the 28th day of April 2023. The hearing of the motion for interlocutory injunction will be virtual. So, let them be served. So let us hear the motion on Friday. Ensure they serve them today. The order can follow thereafter. Because of time, I don't know whether the order will be ready today. So if it cannot, ensure that you serve them with the originating processes.
So we pray this order to be ready and be served along with the processes, and we oblige. We urge this court.
Yes,
thank you, my lord.
welcome. You are welcome. Any other matter, Registrar?
No, my lord, that's all for today.
Okay, thank you, Counsel.
Thank you, my lord.
Yes, we have come to the end of today's proceeding. The court will
the fact that they could deliver true judgment and delay us.